唔該，係咁咧就
Members, we have reached the appointed hour and quorum has been formed. So we start now. Then please invite the officials to join us.
係30啊，係30㗎。算係咁啊，算係咁啊，算係咁啊。OK， 咁你俾我可能跟住我讀嗰份先，我可能佢冇喺手。哦，係得 OK 好。唉。
好
Thank you for coming. I would like to remind members, if you have any direct or indirect pecuniary interest in relation to the two resolutions, you should make your declaration. In accordance with Rule 83A of the Rules of Procedure, no member shall speak on any resolution or amendments of the resolutions if they have direct or indirect pecuniary interest in relation to those resolutions or amendments, unless they have declared the interest of his interest. I don't know whether I need to declare my interest. Just to play safe, I think I would declare my interest. Well, because that would involve me handling fewer small claims. I declare my interest as a practicing solicitor. In relation to the issues raised at the meeting on the 9th of April, the administration has provided a written reply to members. So here, maybe I should invite the administration to briefly highlight the response to the points made last time, so that members may wish to ask follow-up questions. Yes, there were a number of issues raised last time. First, the civil jurisdictional limit of the small claims tribunal, and also the extent of the increase, the adjustment of the limit, and also for the relevant mechanism concerning the district court's civil jurisdictional limits, as well as the establishment of the tribunal. I will say something first, and then I will invite the judiciary representatives to say something. First point, in relation to the jurisdictional limit of the small claims tribunal and also that of the district court, but the judiciary has conducted a very comprehensive review, taking into account things such as the demand for services of the tribunal and the district court. And this review is to come up with a better distribution of cases among the Court of First Instance of High Court, the District Court, and the Small Claims Tribunal. We have consulted stakeholders such as the Hong Kong Bar Association and Hong Kong Law Society. And in order to prepare for the handling of more cases of the small claims tribunal, and also additional premises, well, we work on this limit of 75,000. If this is going to be, the judiciary is of view that it is not appropriate to raise it further to 100,000, because there will be the need of another review and consultation. We cannot just increase the limit from 75 to 100,000 without doing that. And because of the need to conduct a review and the consultation, that means the implementation of the new limits will be delayed. And that will also affect people's access to justice. The judiciary is also aware of the members of the subcommittee as concerned about the limits concerned.
So we have pledged to raise the cost to 75,000, and we will review the caseload for 2 years and see the impact, and we will conduct a further review to see whether we need to adjust the cost. So we urge the committee, the bill committee, to support our work and raise the SCT limits to 75,000. Anything else the government official needs to add? Well, Chairman, we've stated the position very clearly. Let me add that in our response on the last occasion, we talked about the DC court cases. Will they be diverted to the SCT? In our previous response, we had given a detailed answer, and we talked about how the different cases could be diverted from the DC and be handled by the SCT. So there are existing mechanisms to deal with these transfers. Regarding the SCT, the registrar, we have, when we increase the limit, we will add staffing levels. So let me conclude here. So given the response, I have received a letter from Mr. James Toh on 7th of May addressed to this committee, and we have circulated the letter to members, and the request was to increase the limit from 75,000 to 100,000. So I think the government has also received a copy. So at this point, I am aware Mr. James Toh has raised his hand. So let me allow Mr. Toh to explain his position. Chairman, I have other engagements. So after explanation, I thought I couldn't attend. So that's why I wrote the letter. It's not very detailed, but I think I have covered the main points. Chairman, you are aware that I'll make an amendment from 75,000 to 100,000. The reasons are, first of all, the 50,000 in 1999, it's almost 20 years to see the adjustment to 75,000. So setting aside inflation, the division of labor, if it's cases from 75,000 to 100,000 or even 100,000+, if you have a court case in the DC, the legal costs far outweigh the awards. So if it's a limit is or the court case is 75,000 to 100,000, there is a lack of equity. The basic law says that we should have access to the courts. So the appellant doesn't have, or the litigant doesn't have legal representation, then they lose the case, then they don't lose a lot. So there is a deterrent, and cases of tens of thousands don't have access to justice. So from 1999 till now, it's some 20 years, we haven't pushed for raising the limits in SCT. So we are now aware, and the courts are aware of our intention. Actually, a lot of our colleagues are of the same view. But the point is, you want to conduct a review in 2 years' time, you have to review if you're talking about inflation, it's hard to foresee a 30% inflation, so we won't see the factor of inflation raise it to 100,000. So even at 10%, we're talking about 80,000. So we won't be increasing it from 75,000 to 80,000. You'll say wait another couple of years so we can revise it to 100,000. Well, if you talk about caseload, and from 75,000 to 100,000, if you say a lot of cases are now diverted to district court, or if you receive a lot of cases between 75,000 to 100,000 in the SCT, and then you say, I'm not going to deal with 100,000 cases, I'll just deal with 75,000 cases. And unless you have very detailed statistics, and they won't even disclose that information. So if the SCT limit is 75,000 and we have excess costs being waived, so if you look at all the factors and review it, and we have our previous revision was 20 years ago, and then you're not talking about a review in 2 years' time, and even if you adjust it to 80,000, it's still a big gap. Of course, it might not be in line with the rules of procedure, but I want a clear message that if legal costs have to be rewarded, then there is no justice. There's no access to justice. So under these circumstances, I would like to put forward my amendment. And Chairman, whether the amendment is successful, it doesn't matter. If the government insists that will there be a shortage of staff in SCT, initially I think you could be able to handle the caseload, and how many cases are between 75,000 to 100,000. And in the past we didn't have a lot of cases at 100,000 in the district court because they were afraid, they were deterred by the costs. And of course, if that is the case, then there would be no access to justice. If that's what you're going to say, then your position is incorrect. So if you increase it from 75,000 to 100,000, there wouldn't be a substantial increase in caseload. So it depends on what stance you want to take. So Chairman, the issue is I'm quite confident that the increase in caseload would be marginal. I don't believe that they will be overburdened, the SCT will be overburdened. You also have to bear in mind that the DC, you have to cater to cases between 1 million to 3 million, so they have to increase the establishment. So I'm not saying that the judges can run from one court to another to handle the extra workload, but since you are increasing personnel, you have more deployment capabilities. It is not going to be a workload, overwhelming workload. So even if they disagree with my amendment, I think the general opinion is that you will have a lot more legislators speaking on behalf of the public that you should have a larger increase. Okay, thank you, Mr. James Toh. Any special response from the government? Well, as Ms. Chan said, the judiciary stance in proposing the civil jurisdiction amendment proposals. It was done after thorough assessment, and we had consulted the legal industry before making the proposal. So it was done after thorough deliberation. So if all of a sudden in the Bills Committee we were to revise the jurisdiction limits from 75,000 to 100,000, it would not have been done under thorough assessment. And if we were to make any changes, it would, aside from assessing the impact, we would also need to consult the industry. At this point, we cannot support that amendment proposal, but we feel that there are different opinions, and legislators in the Bills Committee, they have also said that they would like to see the civil jurisdiction limit increase as soon as possible. So we would like the committee to support us, endorse our proposal, and we promise that in the coming 2 years, the civil jurisdiction, the SCT, we will conduct a further consultation. And we don't have a default position. We would like, since we need to do a review and consultation and the legislative procedure, it takes time, and if we were at this stage to make any changes, we would, the public would like better access to the courts, and that is in line with our intention. So we hope that the committee can support us to take the initial steps, and in the coming 2 years we will do the review and consultation, and we will run the procedure. Well, Chairman, does that mean that I can put forward the amendment and it is, and I put forward the amendment? Will the government withdraw the motion? I don't understand. Why will it slow down? Could you elaborate? Because this will be a positive vetting. So does that mean that they will withdraw the proposal? Chairman, we had explained just now, our work is to urge members to accept the $75,000 proposal, and we would like other members' support so that the motion can be endorsed. Well, I think you need to give us a clear response. Well, you cannot avoid my question that if I put forward the amendment, you will withdraw your motion. Well, if you were, it's within your rights to do so. But then, if you were to do that, it would create tension in our relationship. I need to maintain order in our meeting. So, so before the amendment deadline, they need to provide a written response. Mr. Wang Dinggong and I also have questions, but I know that there are different questions. Next person with questions is Mr. Wang Dinggong. So I'll set the time limit at 5 minutes, Q&A. 5 minutes. Thank you, Chairman. Mr. James Toe's commitment and scrutiny of bills is commendable, but perhaps we have different viewpoints. We focus on different areas. On this occasion, Mr. James Toe proposed increasing the limit of the SCT from 75,000 to 100,000. I understand his thinking, but there are some objective facts that need to be considered comprehensively.
提高到75000呢個額度。
Raising the limit to $75,000 is something proposed by the judiciary after carrying out a detailed study and having paid attention to the actual circumstances. But Mr. Toad is doing this, is proposing something else based on his personal experience, and he would like to raise it further to $100,000. So what can we do about this? I personally would like to support the government's proposal because the proposal from the government is based on actual work experience. And Mr. Toe's proposal is based on a personal assessment. That is to say, his assessment that the judiciary will not be overburdened with additional cases.
I
hope Mr. Toe would understand that there was formal consultations on different levels before the proposal was tabled here. Moreover, I believe the government has listened to Mr. Toe. A promise has been made that after raising the limit to $75,000, depending on actual circumstances, the government will shortly, that is to say within 2 to 3 years, carry out a review, and if necessary, there will be further revisions. As a matter of fact, this limit of $50,000 has been around for some 20 years. It's since 1999, as Mrs. Toe has said. And it's really not in keeping with the actual circumstances nowadays. So it's a late spring, so to speak. I hope in the future proposals can be more pragmatic and measures can be implemented on a more timely basis. The DAB will support the government's resolution. Yes, Mr. Toe mentioned a point that since 1999, and there's been no adjustment in those years. Well, actually, in 2003, there was a review on the jurisdictional limit of the Small Claims Tribunal. But from 1999 to 2002, there was a deflation. And after the increase in the jurisdictional limit in 1999, there was an increase in cases. So back then, it was decided that there will be no need to adjust the jurisdictional limit of SCT. Thank you for your additional information. But from 1999 to 2003, it's just a 4-year period. But from 2003 to 2018, it's a period of 15 years. So we haven't done this for 15 years, which is, in my view, far too long. And it's my turn. I became the legislator in this current legislature Oh, I have actually written to the panel for a discussion on the jurisdictional limit of SCT. I was one of the first to propose that the limit be set at $100,000. And according to the government, they would like to get the first increase implemented first. That is, increase the limit to $75,000 in the first instance, and that would be the basis for another review in 2 years' time. In 2 years' time down the road, and if things that don't work quite well, then you may, the government may increase it to $100,000 after the review. But I do understand Mr. To's arguments that this should be the limit should be increased to $100,000 in one go, and now. But according to the judiciary's reply, since you conducted the review and prepared the work arrangements based on a jurisdictional limit of $75,000, because with the limit increased, you are going to handle more cases. The last time I asked how many more tribunal officers or how much manpower resource will be required. So I would say that increase the limit to $75,000, and that will be reviewed in 2 years' time, with a view to increasing it further to $100,000 is something I can accept. And I hope the Director of Administration can closely liaise with the judiciary. And that is, they have been working on the basis of a $75,000 jurisdictional limit, and if all of a sudden you change it to $100,000, then all the preparation will have to be redone. And you haven't really assessed the manpower requirement. Then this increase in jurisdictional limit cannot be realized within a short period of time. We want to help people, help more people. We don't want the proposal to get stuck somewhere. So I think members generally are of the view that we should go along with the original proposal. But I have to make this a very solemn request. You have promised that a review will be conducted in 2 years' time. I hope 2 years later you come back and tell us when or how the limit is to be further increased to, say, $100,000. I think that more members of the subcommittee would be in favor of this approach. All right, so perhaps that's how we would consider the limit of $75,000. And Mr. James Toad may wish to move an amendment. Of course, he has every right to do so, but the subcommittee would, for the time being, agree to the limit, the change in limit to $75,000. So that's our preliminary position. Let's see if we got any further replies from the administration and the judiciary. Thank you for your comments. The judiciary has promised that review will be conducted in 2 years' time, and we have actually listened to members' views. All right, so you please work it out with the judiciary. I think that's the conclusion of this part. On the 16th of April, our legal advisor wrote to the administration. A reply has been received, I suppose. Any further comment from our legal advisor? No, so that's done. And we've got a further paper. And that is the amendment to the proposed inclusion of the amendment to the civil jurisdictional limit of the District Court for costs only proceeding in the proposed resolution under the District Court Ordinance. Well, a resolution passed in this council can be invoked to change the jurisdiction limit of the District Court, but it doesn't cover 53A, and that is Section 5 of that particular Section 53A bracket 5. So in the original resolution, we did not cover the Section 53A bracket 5, which is costs only. But since the passage of the Statute Law Miscellaneous Provision Bill 2017, or the Omnibus Bill on the 11th of April 2018, it came into effect after the Gazette. And under Section 73A, there's a reference to the civil jurisdictional limit. So in the future, we can change the the jurisdictional limit for on-cost proceedings by invoking Section 73A. So we'd like to make a change so as to cover Section 53A bracket 5. That is to say, to raise the limit from 1 million to 3 million, which would be in line with the other jurisdictional limit of the District Council. So this would mean that costs will also be covered. Okay. If members have no further question, we can proceed to the cross-by-cross scrutiny. 001. There are a number of papers. Maybe should we go over those as well? Maybe we can use this paper. It's CB24 bracket 4 873/1718 bracket 02. Are we going to use this paper? Okay. Do you have this paper? CB bracket 4 873/1718 bracket 02. All right. We may start now. I will defer to the colleagues from the judiciary. Generally speaking, the amendments are about the raising of jurisdictional limits. So on page 1, you can see, or the next page as well, is about changing the relevant limits. So under Sections 32 of the District Court Ordinance, Section 1, $1 million will now be replaced by $3 million. And on subsequent pages, you can see that 1 million becomes 3 million, or 240,000 becomes 320,000. All numerical amendments in the limits. So that's how we deal with the amendments, so as to reflect the proposals in the resolutions. So from page 1 to page 7, there are changes to the amounts, the limits in the District Court Ordinance. And for Small Claims Tribunal Ordinance, there's a change from an amendment of the limit from $50,000 to $75,000. Members, any comments? Speakers not coming through? Well, it's all about changing the limits, the amount of money.
OK， 好好得。哦 ，OK。法律顧問提一提醒我。
I've been reminded by the legal advisor of this point.
因為
So, as you said, the 53A has some clauses that need to be added, and I see we have to amend it to 3 million. So, as we explained just now, 53A, according to 73A, will be amended. So, when we put forward the motion, we will include the 53A recommendation of amending 1 million to 3 million. So 53A is also dealt with. It will be, yes, we have confirmed that. Well, if that's the case, then I think our clause by clause would have been completed. And I also need to ask the legal advisor any questions on the English version. So Chinese English, there's no problems with the Chinese English versions. So one more question. Just now we mentioned that 53A, we had dealt with the costs of 1 million being amended to 3 million. That has been dealt with. I want to ask one more question. Given the government's response at a very early stage, the judiciary colleagues mentioned in some cases, for example, let's say it was being tried at the district court and the claim, let's say, was 60,000, and now SCT can increase it to 75,000. So theoretically, they can have it retried in SCT. And the question asked on the last occasion, you had given us a written response. The mechanism can deal with it. I just want to confirm. Does that mean it's not the court diverting the case? It's the court telling the applicant that they can withdraw it from the DC and reapply in SCT. But the previous work, if costs have been involved, those need to be settled. I just want to clarify that because it's not in the written response. Chairman, your understanding is correct. The DC and CFI are slightly different. They have a mechanism where cases can be handled directly, but the SCT and DC, their operations are different. SCT doesn't have legal representation and so on, so there will be some difficulties, but your understanding just now was correct. The applicant can withdraw his claim and approach SCT and make another application there. Of course, the applicant would have to consider whether there are some deadlines, time deadlines, and if the deadline does not allow him to do so, the case can continue being tried in the DC. So their claim will not be stopped all of a sudden. So according to the new mechanism, they can withdraw their DC case and have it retried in SCT, but they have to bear in mind the previous work and legal costs that had been incurred need to be settled. Okay. Well, I think that would conclude most of our scrutiny work, and I understand that our SCT and DC motion, we had consulted the stakeholders, including the Law Society, and the Barristers Association, the Bar. So I don't think we don't need a public consultation, and there is no need. Okay. Well, if that's the case, we have completed scrutiny of the bill. So I want to ask the government, when will you put forward your notice, and when will you submit it to LegCo for second reading? Yes, we are contacting LegCo. We have to submit a report to the House Committee, and before the end of the legislative year, we would like to submit the motion, but subsequently, the Chief Justice also needs to make a commencement date announcement, and there's also rules and regulations for the SCT, so that would have to, is subsidiary legislation that needs to go through negative vetting, and after these gazettal notices, then in the second half of the year we can implement the increase of DC and SCT limits. So put simply, we would like to implement the increase by the second half of the year. That's good news. And if you want to put it to the House Committee, you mean that before summer recess you want to submit it? Yes, it would have to be submitted before recess, and to have the increased limit in the second half of the year. So we'll leave that to the Secretary to discuss the dates. If we don't have any other business, Mr. Wong Ting Kong, there's on the motion Mr. James To's amendment. So will the Bills Committee deal with it, or will he make his own amendment? Well, I think we heard everybody's position. Well, you need to have it on the record, because when you make a report to the House Committee, you have to state our committee doesn't have any CSAs. So we heard members' views. We will not act on Mr. James To's behalf and put forward our committee stage amendment. We will not submit our own committee's amendments. Mr. James To will have to do so on his own behalf. So that is clear. If we don't have any other business, then we will announce today's meeting adjourned, and once again we have to thank attending officials, members. Thank you very much.